But I want to also address generally this question here, but let me find out what you're...
The information I had gotten from Richmond was that the Romney and the Paulus ballots were never screened at all in any way against any criteria. But the Newt's and Perry's ballots were screened against the residency of the circulator. And therefore what you have is you can't run a football game with two different sets of rules. And the rules were changed in the middle of the process, and therefore that invalidated the process.
Let me catch up on some things here before I bring another question in. You know, to back up, of course, as you know, the chair or the Republican Party of Virginia came up with a rule that they were not going to check anyone who submitted more than 15,000. They're just going to assume that if you got 15,000, we're going to assume that they're valid. I understand from what I've heard that was never voted on by the Republican Party of Virginia, and I think that the statute does not give discretion to the chair to come up with any such rules. It says that he must certify all the candidates that complied with this section. It does not say he can certify anybody he wants. It has to comply with the section. So that may be invalid. There was even talk about challenging that in terms of the validity of Mitt Romney's signature. My understanding is that Ron Paul's were checked because he came in just under 15,000, and that they checked them there. However, we also heard from one of the witnesses, from one of the people who did it there, that they were given about 1 minute of training. Everybody was doing different things. And they were probably sincere, but they were throwing things out or not throwing things out based on inconsistent standards. And there was nobody there, while there were people there of a database nature, there was no one available to ask substantive questions about whether somebody should be included or not included. No lawyer was there, and they had questions, and they had to finally get somebody on the phone and things like that. So what rules were really followed is a real question, is a real problem. But in terms of like the Newt Gingrich thing, and I'll sum up at some point with the status of the companion lawsuit that I filed on that, which at this point, for a variety of reasons, we may only get out of that maybe some discovery to find out more about what actually happened. For a variety of things, both in politics and life and law, I'm very hesitant to believe everything you hear floating around. You often find out that, especially when people are trying to justify themselves or things, what we hear is not always reliable. I've talked to one of the people who did the counting, another person, not one of those. They checked some of Newt Gingrich's. They were on the day that they were doing Newt Gingrich's, and he said that there were some that were valid, but a very, very high level, or high number of them were not found on registered voter registration lists. And he did notice they were all in green ink and were seemed to be the same handwriting. It could be, and Jerry Gilmore testified at one point that he had access to a mixed bag that he had been able to satisfy it. He also was testifying, I forget which candidate he was testifying for, but he also admitted that he managed to do it. So we kind of have this argument that we've done it before. Politically, the judge did not accept that 10,000 was too much. He thought that that's okay. That's what he went through this various analysis. But politically, I think there's a lot of consensus that probably is too much. Particularly because people don't recognize that the earliest you could have done this was July 1. What I learned yesterday was amazing is that the party didn't have to tell us whether we're having a primary or not until December 7th. And then they're all due on December 22nd. So if you don't even know if there's a primary or not, how are you supposed to collect all these petition signatures?
The only thing I can say is that the RNC mandated that all the states put their revenue by October 1st. So while the December date might have been a date in the law, it was irrelevant from the party's perspective because the RNC mandated that all states decide by October 1st.
But okay, and the thing is that, you know, it's hard to get people involved that early, that's so far ahead of the thing to do the volunteer work, unless you have a lot of money. Yeah, well, that's true. I forgot about how the Zillow. Now, of course, I can think of ways that could have done a better job, you know, learning from Ron and from other people. And one thing I always learn is I don't know the voter registration drive rules. I'd like to get up on that, but I would suggest if you're going to circulate petitions, bring voter registration cards with you so that you can make sure every signature you get is either registered already or becomes registered. I'm sorry, go ahead, Mike.
I just asked a question. I read, I thought in the news account that the judge had, in effect, his reason for rejecting it, that he said that they had 20 months to collect those signatures and they did not. So my question is, did you hear the judge say that? It was reported, I think, maybe Associated Press. But also, I wonder, did it arise that what was part of his rationale that Mr. Gingrich lives in McLean, Virginia, and Mr. Santorum lives in Great Falls? Did those issues come up at all?
No.
As to the 20 months, did you hear the judge say that? It was reported in the newspapers.
No, I didn't hear 20 months, and I think if that slipped by the time he got his written opinion, he specifically said that the earliest they could have started was July 1. So they had from July 1 until December 22nd. But he really didn't. What? Yeah, okay. But he really didn't. The fact that if he couldn't find a constitutional objection to the number at the time, he really didn't have the authority to question that further. It wasn't.
So the only constitutional issue that he ruled on, as I understand it, was the question of the residency of the circulator.
Correct.
Is that correct?
That's right.
So if these candidates had filed their objection early on, the judge might have been in a position to allow them to go on the ballot based on that, the unconstitutionality of the circulator. Is that your analysis?
Well, yes, and let me add one other thing before is that he said you could have come in early and then you could have gone out and brought out-of-state people to get the petition. But although he made arguments early on in a temporary order to the contrary, he decided that if you didn't actually submit the 10,000, he wasn't going to, he didn't see a pathway for somebody to be on the ballot. So the only issue was this a barrier to getting the 10,000 people? Like Mark Tate testified, which hearing, I forget, he's a guy, I don't know why he didn't call me. I think it was, no, Santorum, that's right. He was Santorum, got the 8,000. He said, we had 5 sheets that were disqualified for this reason. They weren't counted, and we want them counted, but that wasn't enough to make a difference. The other thing was that many of you have all heard about the may versus shall controversy in Title 24.2, 545. It says that anyone who wants to be on the ballot may submit signatures. Everybody said, well, normally it says shall. The judge, so maybe, Rick Perry didn't raise this argument. The brief by Newt Gingrich, Rick Santorum, and John Huntsman raised the argument that means you don't actually have to submit the petition signatures at all to be on the ballot. And that presented perhaps a pathway to him to have a remedy. I even put in a very small friend of the court brief. We're at that point. The judge specifically said, no, I don't buy that argument. So he specifically said, no, you don't have to actually put in the petition signatures away. For instance, his argument was, and I tend to agree with him, he said, if you want to be on the ballot, you may submit petition signatures. If you don't want to be on the ballot, you don't have to submit petition signatures. So that's the way he interprets it. He specifically rejected that argument. Now, there's also unresolved whether or not this all violates the Voting Rights Act, but that's still up there. We've got to go.
Yeah.
We've got to go.